basically the way that I break it down to clients who call and they're like, I heard about a will, I heard about a trust, or what is this probate thing, is that I say you have 3 options when it comes to estate planning, right? And how your house gets transferred. You do nothing and you end up in probate, right? Which you've experienced. That means you have absolutely no documents in place. It's a long court process. I think it's like at least minimum 18 months at this point with like COVID and just the extension, right, of everything takes forever in the courts. And then if you need property sold, right, getting it approved and all those things. So depending on the probate, minimum is like 18 years with accounting.
18 months. Yeah. 18
months, yeah. 18 months would be like forever.
Yes.
I mean, people would definitely get their trust done then. But 18 months, right, if that's an easy probate.
Right.
And it's about 5% of the fair market value. So fair market value being what your property could be sold for. So even if you still have a mortgage, doesn't matter, right? The court doesn't care, the state doesn't care. They're looking at fair market value of the estate.
Right.
So it's about 5% and it's structured and set by law. The second option, that's the fee
that you pay for going through probate.
So the time is about 18 months,
yes,
more or less, and the fee for probate is about 5%.
Yes.
Fair market value. The second option is you have a will. And sometimes people are like, I have a will, it's fine.
Right.
Not really, because the will still has to go through the probate process. So basically, option 1 is probate. It goes to next of kin, right? So your blood relatives down your bloodline, or if you're married, right? But they have it, and it's called intestate succession, where it gets distributed to whoever is left. Option 2 is the will. The will goes through probate, but the difference between having nothing and having a will is that the will is instructions. So say, for example, I have a partner who we're not married, so by law, they have no rights to my assets, right? But say we have an agreement that I want him to receive 50%. In the will, I'll say he gets 50% and then the rest goes to my daughter, 50%, where she would have gotten 100% if it was in probate. So the will gives instructions that allows you to be a little bit more specific than the intestate succession, but you're still going through the probate process, you're still paying the fees, you're still waiting on the court's timeline. And then the third option is the trust. And the trust allows you to have your trustee. So basically, I like to say a trust is like a treasure box. Everything you own goes into it, you hold the key. When you die, you get to pick who gets the key. And that person gets the key and can have access to it immediately for the most part, right? There's an administration that has to happen, but the length of time could be 4 months maybe, or you get it immediately if there's waivers signed.